start. In the judgment of the case Eknath Krishna Kadam 27 versus the state of Maharashtra pronounced on April 24, 2025, Justices Revati Mohite Dere and Dr. Neela Gokhale at the Bombay High Court in Mumbai have upheld the conviction and sentence imposed on the appellant, upholding and praising the impugned judgment and order as a well reasoned and legally sound decision. Para. In the High Court's opinion, the evidence on record, when assessed in its entirety, establishes the guilt of the appellant beyond all reasonable doubt. The observations of the trial court pertaining to the last seen theory and reliability of the statements of the witnesses, examined the corroborated evidence, etc., are compelling and do not warrant any interference. Para. The appellant has challenged judgment and order of December 10, 2009, passed by the ad hoc additional session judge Savory Mumbai, convicting him for the offences under section 302 and 397 of the IPC 1860, for the offence under section 302 for the committing the murder of Anil Vaswani. He is sentenced to suffer life imprisonment and pay fine of rupees 300 in default to suffer RI for 3 months for the offence under section 397 of the IPC, rigorous imprisonment for 7 years and fine of rupees 400 in default to suffer RI for 4 months have been awarded to him. Both the sentences are to run concurrently. The appellant is in jail since August 11, 2008 and has been held to be entitled to a set off for the period already undergone. Para. The complainant Harsha Vaswani was residing with her two younger sisters and father Anil Vaswani, deceased, at Khoja Lane, Warsaw, Andheri, Mumbai. Her mother is predeceased. Harsha and her sisters were employed as crowd artists in films. They were in process of changing residence as they had found a place with lesser rent. Anil Vaswani had engaged appellant to help in packing the household items for the purpose of shifting to new house. Para. On July 30, 2008, appellant went to Anil's house at 11:30 p.m. The complainant, her sisters, father, and the appellant were packing household articles till 4 a.m. on July 31st, 2008. They went to sleep in the morning. The sisters in one room and the deceased and appellant in another at 2 p.m. The sisters awoke and after getting ready went out of the house at 4:30 p.m. Para. At that time, the appellant and the deceased were alone in the house, busy packing while living in the house. The complainant made the landlord, who informed her that he would return the deposit on the following day. While proceeding to Goregaon for work, the complainant called her father, the deceased, to convey the assurance of the landlord regarding return of deposit, but the deceased neither answered her mobile phone nor the landline. Para. Upon returning home at 8:30 p.m., the sisters found the house unlocked and unlit. The complainant switched on the lights in the bedroom. She found Almirah in the open doors and articles scattered. The ornament boxes were empty and a mobile phone was missing. There was no sign of father or the appellant parent. Upon switching the light in the hall, the complainant saw red color stains in the northeast corner and in the hall and roll matters near the wall. She moved the mattress and found her father lying unconscious with a head injury. The police at Warsaw station recorded the statement of the complainant and registered the FIR for offense under sections 307, 397 and 201 of the IPC on August 11, 2008 at 12:05 p.m. A trap was set with panchas in town. The appellant was apprehended while traveling to Pune in an Asiad bus. Para. On search of the appellant, two handkerchiefs were found in his bag containing gold ornaments, and he was arrested upon completion of the investigation. Charge sheet was filed against the appellant at the Metropolitan Magistrate Courts, and the case was committed to sessions on November 24, 2008. Para. The High Court has noted that the evidence adduced by the prosecution clearly forms a chain of circumstances, each pointing to the complicity of the appellant in commission of the offense. In addition, there is also an explanation offered by the defense as to how and when the appellant parted company with the deceased during those 4 hours. The principle of law in this regard is well settled. The provisions of Section 106 of the Indian Evidence Act 1872 itself are unambiguous and categoric. Thus, if a person is last seen with the deceased, he must offer an explanation as to how and when he parted company. If he does so, he must be held to have discharged his burden. If he fails to offer an explanation on the basis of facts within his special knowledge, he fails to discharge burden cast upon him by Section 106 of the IE Act. Para. In its decision of the case State of Rajasthan versus Kashiram 2006 12 SCC 254, the Supreme Court has held that in a case resting on circumstantial evidence, if the accused fails to offer a reasonable explanation in discharge of the burden placed on him, that is itself provides an additional link in the chain of circumstances proved against him. Para. Section 106 of the Indian Evidence Act does not shift the burden of proof in a criminal trial, which is always upon the prosecution. It lays down a rule that when the accused does not throw any light upon facts which are especially within his knowledge and which cannot support an theory or hypothesis compatible with his innocence, the court can consider his failure to adduce an explanation as an additional link which completes the chain. Merely stating that the accused left the house after the sister left is not sufficient discharge of the burden of proof, as there is nothing to explain his whereabouts after the claims to have left. Thus, it must be held that he failed to discharge the burden cast upon him para. An in-depth analysis of the facts in this case and the testimony of the witnesses as substantial evidence clearly establishes the Panchashil of the proof of guilt of the appellant based upon established circumstantial evidence. The five golden principle laid down in the case of Sharad Birdhi Chandsarda versus State of Maharashtra 1984 for SCC 116, including the legal distinction between may be proved and must be proved, is established para. According to the High Court, in all human probability, the act of murder of the deceased has been done by the appellant. The appeal against conviction and sentences fails and is dismissed.